Unfair labor practice under the Industrial Disputes Act 1947, Section 2, subsection RA. Unfair labor practice means any of the practices specified in the 5th schedule. The 5th schedule. Unfair labor practices. 1. On the part of employers and trade unions of employers. 1. To interfere with, restrain from, or coerce workmen in the exercise of their right to organize, form, join or assist a trade union, or to engage in concerted activities for the purposes of collective bargaining or other mutual aid or protection, that is to say, A. Threatening workmen with discharge or dismissal if they join a trade union. B. Threatening a lockout or closure if a trade union is organized. C. Granting wage increase to workmen at crucial periods of trade union organization with a view to undermining the efforts of the trade union organization. 2. To dominate, interfere with, or contribute, support, financial or otherwise, to any trade union, that is to say, A. An employer taking an active interest in organizing a trade union of his workmen, and B. An employer showing partiality or granting favor to one of several trade unions, attempting to organize his workmen or to its members, where such a trade union is not a recognized trade union. 3. To establish employer-sponsored trade unions of workmen. 4. To encourage or discourage membership in any trade union by discriminating against any workman, that is to say, A. Discharging or punishing a workman because he asked other workmen to join or organize a trade union. B. Discharging or dismissing a workman for taking part in any strike not being a strike which is deemed to be an illegal strike under this act. C. Changing seniority rating of workmen because of trade union activities. D. Refusing to promote workmen to higher posts on account of their trade union activities. E. Giving unmerited promotions to certain workmen with a view to creating discord amongst other workmen or to undermine the strength of their trade union. F. Discharging office bearers or active members of the trade union on account of their trade union activities. 5. To discharge or dismiss workmen A. By way of victimization. B. Not in good faith but in the colorable exercise of the employer's rights. C. By falsely implicating a workman in a criminal case on false evidence or on concocted evidence. D. For patently false reasons. E. On untrue or trumped up allegations of absence without leave. F. In utter disregard of the principles of natural justice in the conduct of domestic inquiry or with undue haste. G. For misconduct of a minor or technical character without having any regard to the nature of the particular misconduct or the past record or service of the workman, thereby leading to a disproportionate punishment. 6. to abolish the work of a regular nature being done by workmen and to give such work to contractors as a measure of breaking a strike. 7. To transfer workmen malafide from one place to another under the guise of following management policy. 8. To insist upon individual workmen who are on a legal strike to sign a good conduct bond as a precondition to allowing them to resume work. 9. To show favoritism or partiality to one set of workers regardless of merit. 10. To employ workmen as badlis, casuals or temporaries and to continue them as such for years with the object of depriving them of the status and privileges of permanent workmen. 11. To discharge or discriminate against any workman for filing charges or testifying against an employer in any inquiry or proceeding relating to any industrial dispute. 12. To recruit workmen during a strike which is not an illegal strike. 13. Failure to implement a ward settlement or agreement. 14. To indulge in acts of force or violence. 15. To refuse to bargain collectively in good faith with recognized trade unions. 16. Proposing or continuing a lockout deemed to be illegal under this act. Next, 2. On the part of workmen and trade unions of workmen. 1. To advise or actively support or instigate any strike deemed to be illegal under this act. 2. To coerce workmen in the exercise of their right to self-organization or to join a trade union or refrain from joining any trade union, that is to say, A. For a trade union or its members to picketing in such a manner that non-striking workmen are physically debarred from entering the workplaces. B. To indulge in acts of force or violence or to hold out threats of intimidation in connection with a strike against non-striking workmen or against managerial staff. 3. For a recognized union to refuse to bargain collectively in good faith with the employer. 4. To indulge in coercive activities against certification of bargaining representative. The number 4 is to indulge in coercive activities against certification of a bargaining representative. 5. To stage, encourage or instigate such form of coercive actions as willful, go slow, squatting on the work premises after working hours, or gherao of any of the members of the managerial or other staff. 6. To stage demonstrations at the residences of the employers or the managerial staff members. 7. To incite or indulge in willful damage to employers' property connected with the industry. 8. To indulge in acts of force or violence or to hold out threats of intimidation against any workman with a view to prevent him from attending work. Unfair labor practices is also provided in section 25T and section 25U. That is under chapter 5C of the Industrial Disputes Act 1947. The provision for unfair labor practices under section 25T, that is prohibition of unfair labor practice. No employer or workman or a trade union, whether registered under the Trade Unions Act 1926, 16th of 1926 or not, shall commit any unfair labor practice. Section 25U, penalty for committing unfair labor practices. Any person who commits any unfair labor practice shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both.